Perfect. Hi, everyone. Good afternoon. Thank you so much for making the time to join us today. My name is Queen Star Akron, and I am a director here at Whiteboard Advisors. Whiteboard Advisors is a mission-driven communications, research, and consulting firm that supports organizations working to advance educational equity and economic mobility. We are so excited for our conversation today with our senior advisors, Anarima Bhargava and Jeff Salingo. And during our conversation today, we will take a closer look at all of the details of the Supreme Court decision. We're going to discuss the implications on the legal side and in higher education, and forecast how stakeholders across the education system will be impacted. As you can see on my screen, Anarima joined us. We want to make sure that we get a very quick and very lively discussion hot off the press. So to recap this morning, the Supreme Court ruled on whether colleges and universities may consider an applicant's race in making admissions decisions. The court found that Harvard and the University of North Carolina's admissions policy violated the Equal Protection Clause of the 14th Amendment. Now, Chief Justice John Roberts wrote the court's majority decision saying that the colleges and universities must use other criteria in their admissions. The ruling in the UNC case was 6-3 along ideological lines, and in the Harvard case, it was 6-2, with Justice Ketanji Brown recusing herself from the case. Now I'm excited to introduce my esteemed colleagues, Anarima and Jeff, to the conversation for a deeper dive into the case. Now, Jeff Salingo has written about higher education for more than 2 decades and is a New York Times bestseller author of 3 books. His latest book, Who Gets In and Why, A Year Inside College Admissions, was named the 100 Notable Books of 2020 by the New York Times. He's a regular contributor to The Atlantic, and Jeff is a special advisor for innovation and professor of practice at Arizona State University. And he also co-hosts the podcast Future You. Now, Anarima Bhargava is the founder and director of Anthem of Us, a strategic advisory and consulting firm that promotes dignity and justice in workplaces, schools, and communities. She served as the chief of the Educational Opportunities section of the Civil Rights Division in the U.S. Department of Justice. She also served as the director of the education practice at the NAACP Legal Fund. She previously worked in the New York City Department of Education and clerked in the Southern District of New York. And she's joining us live on vacation. So we really do appreciate her making time to give us her hot takes today. So let's jump right in, Jeff and Arima. Thank you for being here. I'm going to start off with Jeff. What are some of your immediate reactions to today's Supreme Court decision on the Students for Fair Admissions cases? Oh, you're on mute, Jeff.
As I said earlier, I think many of us are just still reading the cases, so I don't want to are reading the decision. So I don't want to like put out too much here because I think taking time and really trying to analyze this and discuss it, I think is necessary at this time, right? So I'm not a fan of hot takes, right? So that said, I first of all, I don't think the decision really surprised many. I think that we knew we were heading in this direction. I think there's an interesting carve out from what seems to be an interesting carve out for the military academies from this, and I think we'll kind of look into that a little bit more in the coming days. I think the biggest question right now among colleges and universities and among high school counselors and college counselors and in college admissions officials is what can be used and what can be encouraged, for example. So it seems that in very early readings of this, that students would be able to make reference to their backgrounds, to their race, to how they got to where they are in essays and in other parts of the admissions application. How can admissions officers take that into consideration, I think is going to be one of the questions that's going to be asked by admissions officials in the coming weeks and months. The other thing is that colleges and universities do report enrollment to the U.S. Department of Education by race, ethnicity, and gender. And I think one of the interesting questions is, how is that going to be able to be tracked during the admissions process? In other words, a lot of colleges and universities, a lot of institutions that I have both been in the admissions rooms with and also have talked with admissions deans and admissions readers with, closely track how their classes are coming together, how they're crafting their classes. And I think one of the questions going forward is how much of that's going to be able to be done in the years ahead. So those are just some early thoughts on. Again, I'm still making my way through the decisions and the dissents.
And Anarima, I would love to hear your perspective. Was anything surprising to you and some of your immediate reactions?
There's a lot that's surprising. But there's also a lot that's sort of, I mean, it's a very interesting decision because as a legal decision, which I can get into, but I will actually not start there. As a legal decision, it's rather strange, right? And then let me explain why that is. But let me go back for a moment, right? Which is the question in these cases was whether or not universities could take account of race as a factor to promote the compelling interest in diversity in higher education, right? So there was a couple of questions that we generally are not surprised by. We didn't expect that we would be able to consider race as a factor, right? After these decisions, that is in fact what we have now, is that we can't consider race as a factor, an individual student's race. But there's a question about sort of what is the court going to say about the compelling interest in diversity in higher education. And what you get from the court today is the part that I think is sort of interesting, is the court's not saying that there's not an importance and educational benefits of diversity. It's not saying that there's not even a compelling interest in diversity. What it's saying is the court doesn't feel like it has a way to measure that in any kind of concrete way. So it doesn't know how do you figure out whether or not you've achieved the educational benefits of diversity. And because of that, it's saying, hey, we didn't want, when the University of Michigan cases came out in 2003, 20 years ago, the thought was that this kind of admissions process, considering race, wouldn't go on forever. So we don't know, if we can't figure out whether or not you reach the educational benefits of diversity, we don't know when that process ends, right? So part of this is a judicial competence, institutional competence problem. Like, we don't have a way to measure it. And all of the things that you're describing, i.e. human things, like the benefits of diversity are humanity. It's how we see each other. It's how we view each other. It's how we understand each other. It's what we know we have in common. Those are things that obviously are very difficult, if not impossible, to measure. And so what you get from the court today is, because we can't measure it, we're sort of questioning, right, the sort of interest in diversity. And so that's one piece of this. But I want to really underscore what Jeff, started with in a way, which is, what's the message to young people around the country? It's not that diversity isn't important. It's not that diversity isn't something that universities can pursue. And it's also not that you can't tell, you can tell your own stories. You can tell stories of your racial experiences, about your identity, your backgrounds. How universities are going to take account of that is still going to be a question. And I think it's going to be a challenging one for them. But it's not that students can't tell those kinds of stories. So that's the first part of this. The second part is that you have a court really taking, doing a number on our history of why it is that we consider race at all, right? Which is, the reason we consider race is to be able to address segregation and inequality and the way in which it persists in American life. And what we have here is a decision that essentially is trying to say that, we're going to colorblindness. Like, you cannot consider race in any way, whether it be for a plus reason or a minus reason, but we don't want you to consider race in that way, because we don't think race should be part of American life, which obviously is just totally doesn't square with what American life and the way that and the way in which race plays out, and particularly in education, in so many different ways. And so you have a really a exploration of Brown versus Board of Education that you'll see Justice Sotomayor in her dissent, and Justice Jackson in her dissent really take to task, because it is a distortion and degradation of what it is that Brown has meant in this country and what its importance is, which is that we all we need to be able to have a country in which we can pursue racial equality and ensure that people have opportunities, and not to suggest that either that work is done or that it cannot be done. And then the last thing I'd say is the one of the perverse things about this is that the court wants, they're like, let's hurry it up. Like, we don't want to have to continue to consider race. Well, if you take out race as a factor, then it's going to make it harder. It's going to make it slower. If we can't actually consciously and intentionally and carefully and thoughtfully think about how it is that we address racial inequality, it's going to make it harder for us to get to a place where that is, as we would all want, not be something that that maps the kind of opportunity and the kind of way in which we can actually reach our potential in America today.
Thank you so much for that. And I'm going to pivot to you, Jeff, in just a second. I saw this question in the chat, and I just wanted, for our attendees that are joining us, there is a chat and also a Q&A box if you have any questions that we can address at the end. But Jeff, there was a question about, like, how did we get here? And that is something that we want to make sure we spend some time talking about. What has been the history of affirmative action or race-conscious admissions in higher education? So can you give us a little bit of an overview of the journey to how we got here today?
Yeah, I mean, we've had several cases that have come before the Supreme Court, starting with the Bakke case in the late 1970s. We had 2 Michigan cases from their law school and undergraduate in the early 2000s. We had cases from the University of Texas about 10 or so years ago. And then we've had these cases from the University of North Carolina and the university, and Harvard University. In those other cases, what was interesting is that the plaintiffs were white, and in these cases, we got a lot of. What was interesting about these cases is that there's a belief among some, and this is not a widespread belief, according to the polling and the research, that affirmative action has also hurt Asian American applicants to highly selective colleges as well. And so that was a little twist in these cases specifically. But one of the interesting things that I think was quoted in this case is that back in the Michigan cases, now almost 25 years ago, that Justice Andrea O'Connor at that time had talked about this need for when affirmative action would end, right? When the need for race-conscious admissions would end. And I think in just searching through the case or through the decisions today, the term 25 years was cited, I think, a dozen times or so. And so it was interesting to me. What was interesting to me is that there was this kind of clock put on this by Justice O'Connor in those Michigan cases, and that was brought up a lot during the oral arguments in the fall in these cases as well. I think the bigger thing that is interesting here is that colleges and universities are really, I think, one of the last places in America for rising adults to experience the potential diversity that they're going to experience, particularly in the workforce, and why so many companies and corporations have supported the use of race-conscious admissions over the years is that increasingly, as we know, in America, we're more probably segregated than ever before, right? That it's very likely that a student will not experience a lot of diversity in their K through 12 schools in where they live, given how we fund K through 12 education. And so the idea has always been that there are huge educational benefits, which have been well documented, to diversity in college. And we know that this is what really just kind of makes me, this decision I disagree with on a number of levels, but the one part that I really worry about is that I know from talking to and interviewing students over the last 25 years I've been writing about higher education, is how much diversity has helped students from all socioeconomic backgrounds, all races and ethnicities, right? How it helped me, right, as a white man from northeastern Pennsylvania when I went away to college 30 years ago, and that if I believe that even despite this decision today, that colleges and universities will find ways to continue to diversify their campuses, because they need to do it, first of all, for purely economic reasons, right? We know that the country is becoming more Black and brown. We know that the country is becoming socioeconomically poorer, and that in order to just kind of, in order to fill their classes, right, they're going to have to figure out ways to attract and enroll, accept and enroll a larger group of students. So I think they will do it for that reason. I think they will also do it, though, because they know that both from an educational standpoint, but also from an outcome standpoint. If you talk to a lot of, I end up talking to a lot of career center people who run career centers, who recruit employers to campuses. And I will tell you, especially at these big campuses where employers are trying to figure out, okay, am I going to go to the University of Illinois, or am I going to go to the University of Wisconsin at Madison? They want to know the racial and ethnic composition of the senior classes, right? Of the classes, right? They want to make sure that if they're going to put time and effort into recruiting at these colleges and universities, that they are going to find a diverse group of students. So I think just from a practical standpoint, I think colleges and universities will put out a lot of statements in the coming days about their commitment to diversity on their campuses. But from a practical standpoint, I think that one of the reasons why they will look for any way to do this going forward is both from just a practical standpoint on filling the class, but more so that they know that that so much of their outcomes are tied to employers who value this on a number of fronts.
That's a very good perspective. And Anarima, please feel free to jump in here as well and provide a little bit of that legal background and then also the ramifications as well.
Sure. So a couple of things. So just in terms of the history of this line of cases, as Jeff was talking about, this decision is a real departure from the line of cases, right? It doesn't actually use or employ the same kind of legal standard. It really sort of leaves you with a question of what the legal standard is in this case. It goes back to a standard that we saw in a case, Virginia Military Institute, which is really about women and gender and not around race. And this idea of like trying to make sure you have an interest that you can measure concretely is something that's new to the conversation in some ways, right? So what we see here is a very, again, it's a strange legal moment, because there's a couple of things that we distinctions that have been really important in the past. So for example, there's a distinction that's been drawn when race is used for a benefit, for something like promoting diversity, versus when race is used to discriminate or to limit or to in ways that are quote nefarious, or to use the court's term today, negative. What we get from Justice Roberts today, from Chief Justice Roberts, is something that says if race was a factor in a student's admissions process and helped out a student in some little way, right? He's characterizing all of that as negative, because he's saying if it helped one student, it had a negative effect on some other student somewhere, right? And that's a pretty extraordinary moment, right? Which is to say, and I think again, I am like Jeff and many others trying to digest a 237-page opinion, with many different nuances to it, and to understand what it is that sometimes the Chief Justice and others mean in terms of the examples they're using. But the way that I read it is that, there's a suggestion that any consideration of race is negative or is a stereotype. And that's certainly has some anchors in Chief Justice Roberts' opinions in the past, where he's saying, any discrimination on the basis of race is discriminating on the basis of race. So he's never been a fan of any consideration of race in this way, but we see that again today. And I think that the part that, again, to speak to to just pick up on some of what Jeff was saying, there is no question. And if you look at Justice Jackson's dissent on page 23 and 24, she talks about the universal benefits of considering race. She talks about the universal benefits of what it means to actually have students be able to go to school together at a time where we are as segregated as we were, since 1970 in terms of our schools. And so in that context, the idea that like no one's really questioning the goals here, but we're making it harder I'm going to keep going back to this because I think it's an important part of, how do we actually think about from employers to the military to most importantly, K through 12 higher education institutions to all of us, how do we actually think about not, continuing to move forward at a time where like, look, we've all been at this a long time and it's challenging and it's tough and it's hard when we get things that suggest to us that we have more limited means in which we can actually move forward. But it's going to be, it's going to be a collective process to do that. And I do think that the dissents really lay out in great detailed form sort of the history of why this is important in terms of our schools, in terms of our healthcare, in terms of how we work together, and also the disparities in wealth and income that really underlie so much of what we're talking about in terms of opportunity today. This decision is upsetting. I mean, when I first read it, I was like, "This is a horror decision," and it is, in part because it just doesn't account for reality, like in terms of what is going on in America today, and frankly, what's going on in our schools. And so, to suggest that like universities, have a more limited means, but to suggest in some ways that like we're at a race end moment is really the problem of the bulk of the chief justices and certainly some of the concurrences as well.
Something I want us to double click on, Anarima, is like this idea of, does this impact other existing civil rights and equal opportunity protections in education? Like, do we find that this is going to impact some other things that some other protections as well? So I would love to hear your take on that, Anarima.
I think we're going to need to figure that out. And so I think there's some important things to note here, right? Which is, this really is, there's a lot of conversation about admissions and zero sum and how the particular legal conversation plays out in that context of zero sum admissions. So, I would say that you have a decision that really speaks very directly to admissions from the Chief Justice's role. And does not sort of stray away from that. That does not mean, and we certainly know that there are many who brought these decisions, who have been pushing forward in many different areas, that the purpose of them bringing these cases was, right, to try and really question and cast doubt on the value of diversity across the board, not just in higher education, really question a number of the programs that allow people and support people in actually being able to stay in school. And one of the things I would say is, I've always hated these cases for the following reason, which is admissions is just one moment in time, right? It's not everything that leads up to that moment of admission and everything that comes after it. What we know in terms of whether or not students are being able to succeed is retention, financial aid, support, mentorship, the ways in which we're actually supported along the way, the kinds of pathways we have. Those are really important in terms of whether or not that admissions moment actually happens, but also whether or not we're able to continue to thrive. And when we talk about the implications of these decisions, I think the suggestion of color blindness certainly is going to have some implications. They want it to have implications in other parts of how we look at higher education and how we work and are in the world. And certainly, I'd say atmospherically, these are the same people who are bringing the cases and bringing the challenges to our freedom to be able to learn and have our histories be in books and be able to tell our own stories in a whole bunch of contexts. So we can't separate these things out. This is an effort to try and erase race and our identities from multiple parts of the ways in which we learn and we engage with one another. And so I don't know what the implications are going to be for things outside of admissions at this point. I think we're going to have to sort of figure that out. But certainly there will be an effort, and we'll see it coming out of decisions of people saying, this has far-reaching consequences, and you shouldn't be able to consider race in a whole bunch of ways in other contexts. That is not what this legal decision says, and it's holding. But I don't doubt for one moment that we're going to get a lot of that in the coming days and months of trying to expand out this to say, there's some ways in which it impacts other kinds of race conscious programs or ones that take account of race in some way.
That's very helpful. And I'm very mindful of the fact that we are maybe 2 hours past this decision. So we are all having a very emotional response to this. So I want us to now pivot a little bit to forecasting for the future. After the hype dies down, how do we anticipate a major shift to occur in how we discuss affirmative action, Jeff? Because I'm very curious, like on the higher education side, I think we had a conversation that maybe we were expecting this decision. So maybe there have been things already put into place as well to prepare for a post-decision America. So I want to hear a little bit about what do we anticipate the shift becoming in how we discuss affirmative action?
Yeah, so a couple of things, and I actually answered some of these questions in the chat. And I'm sorry, I live in Washington D.C. and the air quality here is so bad that I was just outside, so excuse my coughing. So most of the selective colleges and universities, where in admissions, this has the biggest impact, right? Because I think it's important to remember that most colleges and universities are not very selective. In other words, they take most of the applicants who apply. They also, by the way, tend to be the more diverse institutions on top of that. So this is really on an admission standpoint. We can talk about the other questions we're getting about financial aid and others that in a minute. But from an admission standpoint, the impact is great. Most will be most felt at highly selective institutions where there are multiple applications that are denied for every spot that there is. And that's why, by the way, when the Chief Justice said admissions is a zero-sum game, it really isn't in some ways where one applicant is denied and one's accepted. In reality, it's 9 applicants are rejected for every one who is accepted. So a lot of very, very qualified people of all backgrounds, of all races, of all ethnicities, of all genders, of everything are denied admissions to selective college admissions. I think that's an important point to remember today. But anyway, most of these colleges and universities have been trying to, have been working through this. They anticipated this decision, and they will be putting in place, now that they have a decision, discussions over the next couple of months with their admissions officers about what can and cannot be done. So it's going to be immediate, right? It will impact the applications they'll start reading as early as this fall. For admissions. I think one practical impact, by the way, of this is that test optional admissions is here to stay. I think that we're not going to see the end of complaints and lawsuits around admissions. This case is not the end of anything; it just will continue on. And I think that testing and test scores have been used by plaintiffs over the years around the impact of using race as a factor in admissions. And I think it's just going to be a lot easier for institutions not have to deal with that front in any complaints or lawsuits that they get. And so I think it's just going to be easier for them not to have. There's many other reasons why I don't think they're going to bring back testing, but I think this is one of them. I think the big impact, or the impact that is yet to be discussed, is one that several people in the Q&A are asking about, are scholarship programs, pre-college programs. There's a host of programs that use race as a factor in them, right? Whether again that's scholarships, aid. There's a lot of institutions, for example, in Washington State and California and others, where by state law they had to stop, or state law that they had to stop using race in admissions. Many of them have started kind of pre-college programs to diversify the incoming pool of students. Others have used socioeconomic background as a factor. I think one of the questions that I haven't seen discussed anywhere yet is the impact of this on those other things that are where race is used in college admissions, not in terms of deciding who gets in and why, but more so in terms of diversifying the pipeline and also helping students around financial aid.
And I would love to go ahead, Anurima.
Just to build on that this is another way in which this decision is quite different from going back to 2007, there was cases about K through 12 diversity, and they really laid out like, here's the other things you could do. You could take account of, the neighborhood of students in, or you could take account of other kinds of factors. You don't have that in this decision. It's not sort of going through, these are the other sort of possible options you may have. And so part of the reason we're just not going to have the answers really for, what are the implications of this decision for other kinds of programs, is that it's not directly addressed. My take on it, from, again, a very initial hot take on it, is that this is a decision that is really focused on admissions, and consequently it doesn't reach that far, in its holding itself, right? But I think the important part is, there's a lot. I see the questions in the chat. Scholarship programs, mentorship programs. So much of that has to do with the setup of those programs, and so it's very hard to sort of make any sweeping statement about what's going to happen to a range of programs that might have race come in as a factor. When we do legal analysis of those kinds of programs, it's often quite nuanced, right? And so it may be like, is the university administering the program? Is it not administering the program? Is it a private funder in some ways? There's lots of things that are going to come in. And so I want us to be careful not to jump to any quick conclusions about how it's going to impact those, because unfortunately it's often a very particular analysis for the program we're talking about. What we would say is that, as Jeff already spoke to, there are 9 states in which this was a reality before this decision, right? Where places like California and Michigan, where there had already been a situation in which you couldn't take account of race as a factor in admissions in this way. And so we have a lot of information, right, about what works in terms of looking at other kinds of factors, what doesn't work, what are the ways in which we can sort of have programs be in place and invested in that might mitigate some of the impact of this kind of decisions. And so what I think we all want to look to is like, what does that look like going forward? And what are the ways in which we can actually hold up some of that work and that experience and that research, and what it is that we've learned, certainly since the days of Prop 209 in California, about how it is that we can actually address the situation that we're in. And so that's the pivot that I think we should really go into, which is not what are all the different ways in which we can't do some things, but what are the better and effective ways in which we can, right? And I think there's a good amount to go on in that. The last thing I'll say is there's a number of questions about what other factors, what impact does this have on other factors? It doesn't, right? There's some conversation about gender, but looking at the decision again as a hot take, I don't see gender coming in as something that's getting put into question in different ways. But it really is a decision about race and only race, and so that means we again have this really perverse moment where we can consider anything else, but we can't even consider someone's ancestry, right? When you think about legacy, as Jeff and I have talked about in the past, like when you think about something like legacy, it really is about someone's ancestry in terms of a preference that someone might get in that way. But we can consider all of those other things: class, neighborhood, other parts of your background, just not race. And so this doesn't have implications as a legal matter to things outside of race at this point.
And I'm glad that you brought up.
I think that's, if I could just add on to that, I think that's an important point, that that there are a lot of tools in the toolbox for colleges and universities. And, I once had an admissions dean tell me when I said, "Oh, I see you've increased the percentage of Pell students, the percentage of Black students, the percentage of Latino students." And I asked him, like, how did they do that? And he said, "We just worked at it." Right. We put our effort into, and our money and our effort into doing this. And there's a lot of tools in the toolbox of colleges and universities. And the question now is, what are they going to be able to use? And I think the discussion here today is they probably have a lot more tools than they think they do, or they know they have a lot more tools that they think they do. I think now the question is, do they have the commitment to use them?
And while you're chatting, Jeff, I'm curious about the conversation about legacy as well. Can you touch a little bit on how legacy now plays a role in affirmative action, in the affirmative action conversation?
Yeah, I'm kind of waiting by the minute for the first lawsuit to be filed on legacies, right? I mean, I'm not quite sure how colleges and universities really justify the use of legacy admissions today. I mean, it's been kind of going by the wayside anyway at a lot of places, and again, matters a lot more at the more selective institutions anyway. It's been going by the wayside for a long time, and I'm not quite sure how any of the selective institutions, while on one hand trying to defend their use of race in admissions, but also defend their use of legacies, which largely benefit white students because that's who they largely enrolled for so many years, right? So I'm not quite sure how they defend that. I think the other interesting one to me is athletes. We know, for example, at Amherst and Harvard and a lot of selective colleges that the majority of athletes are white, and that most of those spots are also saved in the admissions process for athletes, so they can not only field a team, but in their mind field a competitive team. I'm not quite sure. I think it becomes a lot harder for universities. Not to say that they can't have athletics, right? But I think it's much harder for these more selective institutions to justify why they continue to save these spots for athletes.
Very, very interesting. And I think that once you bring in legacy and you bring in athletics, it definitely I think it brings a whole lot of nuance into the conversation as well. So thanks for talking about that. And so I'm curious now, is this the end of affirmative action cases? Do we think that this is the end of it? Should we, lock in for a more, for lack of a better word, chaotic future when it comes to affirmative action? So Anna Room, I'm very curious to hear your thoughts. Should we expect more cases in the future and more cases around race-based admissions?
No, I don't. I think this is the, look, there's lots of different definitions of what affirmative action is, right? So I'm just going to define it in a certain way because I want to make sure we have a collective one of what we're talking about. If you think of affirmative action as the consideration of a student's race as one factor in admissions, I think we're at the end of that line, right? I think the question of, what are the ways in which someone could pursue a compelling interest in diversity, racial diversity in higher education? There may be some conversations around that, but I don't think those, maybe people will litigate, like, a student talks about their experience growing up and someone will say that student talked about their race in their essay. I just can't, I'm not saying that that's not going to happen, but I certainly think the sort of bigger questions, at least we're left with a legal standard that I think is really difficult to even be able to try and bring a case under at this point, and on any side of it. And so what I will say, obviously, is that we have a line of cases. There's a number of cases that are pending around high schools, right, and admissions in high schools, and the implications of these cases for those, cases that coming out of Thomas Jefferson High School in Virginia and other places. That's something to watch, and we certainly will want to talk about, so what's going to come out of this decision, and how it might impact what's going on there. So it's not that we're not, obviously, it's not we're at a point where we no longer have cases around segregation. We no longer have cases around racial inequality in education and how we address it. It's that this particular conversation around how you can take account of race as a factor in admissions, I think is at its end in whatever form.
I agree that it's at its end, especially in, I think, these big landmark cases. But I do not think that we're going to see the end of litigation and complaints to the Civil Rights Office at the Education Department and things like that, right? At any time, I think that there is a limited number of seats and way many more applicants than there are spots. I think that we're going to continue to see complaints on this front. Whether they have standing or not, or whether they're legitimate or not, is another question. But I think there's going to continue to be debate and churn over this in so many ways. But again, I agree that probably at the there have been a lot of landmark cases on affirmative action before the court. We talked about a couple of them going back to the late 70s. I think maybe for that, at least for now, those are done with this.
And two more questions.
No, I agree with that. We're never going to be a point where if there's a selective admissions process and there's only a certain amount of people that get in, there are not going to be people who are aggrieved in America. Like, let's just be, that is always going to be true. the landmark cases, I think we're near the end of that line.
And do we think that this is going to transition over into private? Or do you think this is going to be like private organizations? Do we see that affirmative action might come up, or is this purely an education, higher ed issue?
These decisions are purely about education and higher education. They're purely about higher education and admissions, excuse me. I do think there is, and we know this because they've already signaled this, there is going to be a concerted effort to broaden this out and to suggest something, about, what we can do in terms of diversity in private workplaces and in employers. But I want to just be very clear that there's nothing in this decision that suggests that overextension, and it really is about admissions and the admissions process and the particular interest that is at play in admissions, which is diversity in higher education.
Perfect. Jeff, anything you want to add into how this might impact education overall now moving forward, even outside of private?
No, I'm that's where I'm not a lawyer. I stayed at a Holiday Inn Express last night, so I know a little bit, but no, I don't want to delve into that. Okay,
perfect. Well, that gives us good enough time for us to jump into our Q&A portion. Thank you all for a very robust conversation. I think that the hot takes were good, and also it just allows us to really frame up the legal perspective and also the higher education perspective. So let me go through a couple of these questions right now. So one of the questions that we had is this the tipping point where if we take race out as a factor in this space, are we going to take out of it in all other places? So affirmative action in work placement programs, apprenticeship and hiring, for example, this seems like it will only fuel the arguments of primarily white people that consider race itself as unconstitutional. So is this the tipping point? Essentially, I guess that's like the main question. Is this the tipping point where we're going to take race as a factor in almost every area in this country? Jeff? And
I certainly don't think it needs to be. And I think part of it is for us to continue to understand the ways in which race plays a role in ways, maybe that all of us maybe wish it does not, right? In the mapping of our opportunity in America. And so as that continues, it's going to continue to have a role. And certainly, again, I'm just going to go back to this. There's nothing in this decision that suggests, extension outside of the higher education admissions context.
Got it. And then do we see states able to override this decision? I think you talked about it in Arima about California in the past. Like, do we see that?
No. So states can't override.
States can't override. Got it. Another question that we had is for Jeff, does this impact race-based hiring or DEI efforts in non-education areas? Or yes or no?
No, again, I'm not a lawyer, but no, but obviously this can be used in future cases in other areas, but no, not in this case.
Got it. And then there was a question about regarding the decision, what is your greatest hope and fear moving forward? This is such a great question. Like, what is your hope and fear moving forward with this decision? Jeff or Arima?
Sure. I'm going to go with hope okay. I'm going to go down that route. My hope is that we are in a divided America at this time, right? We are in a time where so much of what we understand, when we are segregated and we don't get to be around people who are different than us, it is difficult for us to understand what we share, what we have in common. It is difficult for us to understand what the magnitudes that we have to learn from each other. And my hope, right, is that this decision, once again, right, affirms, talks about why that's so important, right? Like and no one's questioning that, right? Like that's not what this decision is about. It's not questioning the importance of us being able to have those spaces. What it's suggesting is that we have to be limited and strange and contorted in how we get there. And I hope that this decision is a wake-up call for all of us to remember, right? That this isn't just on universities. It's not just on corporations. It's not just on employers. It's on all of us to figure out how do we actually find some ways that we don't just believe what it is that someone else is going to suggest about who we are and what we're valued for and what our talents are, and that we're going to be able to have some spaces that we fight for, and it's for everybody, right? Like this is not about any particular group getting ahead. This is about everybody getting ahead because we're actually like in a space together. And so that's my hope out of today, is that we have this case that's about something really narrow, which is zero-sum admissions in selective institutions, which are a small part of, as Jeff has talked about, the higher education, process. But it becomes a decision that has us have this conversation once again as a wake-up call of what it is that we need to be able to learn and play together in America so that we can live and work together going forward.
Got it.
That's my hope.
Yeah, and I think what this will do is force colleges and universities, which frankly I think have been pretty lazy about efforts to recruit more talented students from all over the country, right? As we always say, talent is everywhere, opportunity is not, and I think that they've been kind of lazy about recruiting and finding students all over the place, and I think this will now force them to really look at their practices and how they've done that. And going forward, I think that there is a way to find students to fill these classes, continue to have diverse classes by not using race in the admissions in the actual decision-making process. They just have not done that for the most part, and I think this will force them to kind of rethink that. That's my greatest hope.
Got it. And so for you, Jeff, there was a question about how can colleges push back on this ruling? Do we expect the colleges to push back on this ruling and continue to encourage diverse student bodies with an inclusive admissions process?
Yeah, I mean, I think you're already seeing it, right? I've seen, statements from Harvard and a couple of other schools already in the last 3 hours. Obviously, that were already prepared and ready to go, knowing where this decision was likely going. So yeah, they're going to push back, but they're going to follow the letter of the law. I think they're going to look for creative ways of trying to figure this out. And again, I think they've already been in the process of doing that. So I don't think they're obviously going to follow the law. I don't think any university is going to say they're going to break the law, right? But I think that they will push back in public ways, and I think they will look for ways that they could continue to enroll diverse classes.
That's very helpful. And I know you're on vacation, so I want to be mindful of this last question I give you.
Yes. Well, Queen, I just wanted to say the president has come out. The press conference is happening around now, and there's a statement and executive action that will come out from the White House and the administration. And I do think that just to this point, like. There's going to be legal guidance. There's going to be, that will come out about the legal and appropriate ways in which we can continue to pursue diversity, but also address racial inequality and expand opportunity, which are really the touchstones of what we need to be doing in education today. And so that I think there would be some ways in which I hope that we are in a process that we are thinking creatively and presently about how to do that. And look to the many leaders in this space, from the administration to higher education to, frankly, so many of the folks who are on this call who are educators and innovators and thinking about these questions about how we do that going forward. And I think there's going to be room to do that, and I think room for us to actually really think effectively about how.
Absolutely. And do you think there's anything the average individual can do to really make sure we're uplifting voices of POC or people of color in higher education spaces? This is for Anarima or Jeff.
Yeah, no, I think, again, remembering that, like, we most of the time don't map to what it is that we think about others, in terms of our failings, our purpose, our mission, our who we are, like what we're about. We're strange, quirky beings, and I hope that we end up in a situation where there are spaces where people really listen to one another, and are in spaces where at this time where, like, we're really prone to believe something about someone that we might based on a characteristic or identity that they have, that we open up those conversations. And so that's what that's what we all of us have to be able to do, and stop the silencing, right, and the shaming and the feeling that like these are not conversations that we learn about each other are ones that make us better, and don't make us ones that we're engaged in negative ways with one another.
And just to follow up, and just to follow up on what Anna Rima said, the president did make some comments just now while we've been on this webinar, and I just got a readout from somebody who was watching it, and the president is calling on institutions to give serious considerations to students who to looking at the financial means of a student or their family, where a student grew up and went to high school, and the personal experiences of hardship or discrimination. So, I mean, the education department is has been planning all along to give some guidance to institutions. And so again, just to show the significance of this decision, it's also interesting that the president, who obviously makes comments on many Supreme Court decisions, has decided to make a comment on this one within a couple of hours.
Absolutely. And I know, Anna Rima, I want to be mindful of your intrinsic.
I apologize. Thank you so much for having me.
Enjoy vacation.
A pleasure. And there's a lot to unpack here, and we will do so. And we look forward to doing that with all of you, and really appreciate you being on.
Enjoy great air quality for us in the DC area who are suffering.
Yeah, thank you.
Thank you. And Jeff, before we hop off in a few minutes, there was a question about, does this impact faculty in higher education institutions? Does this impact diversity at all when thinking about that?
Again, I think any of these decisions could be used in future litigation around this, but no, it's really focused just on the efforts around admissions.
Got it. And then our last question that we have here is about financial aid. Does this impact financial aid moving forward?
Again, I think that it's hard to know. It depends on how those financial aid programs are constructed, but no, it's from, again, my quick read of the decision and what I've been reading so far from the lawyers who know 10 times more. No, the answer is no on that.
And I said it was the last question, but there's this one question I want to make sure I highlight. What strong questions should we continue asking in our ongoing discussions in the education community? Well,
I think the biggest one is we tend to talk about admissions and access as just getting in the door. I think the bigger question that we need to ask is that an admissions offer is not an enrollment offer. It's really the financial aid that's the enrollment offer. I mean, I think the biggest hurdle to higher education for most students is paying for higher education, not getting it.
Hot take. Very much so. Well, thank you so much for making the time. Thank you for allowing us to understand the higher ed implications and just the history of everything that got us to this moment. Are there any parting words you have for our folks before we hop off?
No, it's just less than 24 hours. We're probably going to have another big decision in higher education, and that is with the student loan forgiveness. The administration's plan to forgive us a part of student loans for some students, for some graduates, or those who hold student loans, I should say. So we should have that decision maybe tomorrow.
Yeah, so be on the lookout. I believe that at Whiteboard, we are having, please check out our website and our LinkedIn pages, because we do have blogs talking about the pending case coming tomorrow. And then also at Whiteboard, we have a host of experts who are continuously having this conversation about all the hot topics in education. So thank you all for making time, for spending your lunch hour with us if you're on the East Coast, or for the West Coast. Thank you for starting your morning with us. We hope you all have a lovely afternoon, and take care of yourselves and enjoy the holiday weekend. I'm Queen Star Akron. Thank you, Jeff, for joining us. Have a great one. Bye.